Good morning. This is Senate Judiciary by Thursday, February 11th, 2021, or Abraham Lincoln's birthday eve. People forget that now with President's Day. April 12th is Lincoln's birthday, and I think we should celebrate that given what's been going on in Washington. Today's first topic is S7, which is an act relating to expanding access to expungement and sealing of criminal history records. Our witness is Sarah George, the state's attorney of our largest county, Chittenden County. So Sarah, welcome to Senate Judiciary. I think this is your first time this year.
It is my first time. Thank you for having me.
Happy New Year. I guess it's a little belated.
That's all right. I'll take it.
Nice to have you with us.
Thank you. Thanks for having me. I know that this bill was initially discussed on January 14th, and I had sent an email, I think, to all of you right beforehand. I wasn't aware that it was being heard and just wanted to get one quick thought out or comment out to the committee. I can readdress that, but since I was asked to testify and looked into it a little bit more, I would add just a couple of other things. So with regards to the email that I sent, it was really just an addition of one word or two words on, I think it was page 16, line 17, that essentially, at least my reading of it, prevented state's attorneys from stipulating to expunge felony property crimes. Really ever, if you read it in a particular way, the petitioners could seal by stipulation, but could not expunge by stipulation. So the recommendation was just to add, the court may grant the petition to seal or expunge without a hearing. And then I also I had looked over prior testimony and was given a copy of Attorney O'Reilly's testimony regarding the bill. And I would just echo her thoughts on the technical amendment to effectuate the surcharge amendment that was done. There is some pushback within the judiciary around what that really means and whether or not it's really in their discretion to waive the surcharges when doing expungements. They are still occasionally being denied due to that surcharge. So I do appreciate her language that she suggested in her testimony, that I believe was just proposed amendment. The surcharges imposed by this section shall not be waived by the court except as part of an expungement or sealing proceeding where the petitioner demonstrates an inability to pay. I do think that would be incredibly helpful for a lot of the expungements that we're doing in Chittenden County.
Yeah, and that was what a great deal of the testimony back before COVID hit in Winooski. When we had the public hearing, I believe you were there.
I was.
And a lot of the witnesses had significant surcharges that were making it impossible for them to make the payment.
Yeah, and I mean, our surcharges in general are significant for people, and some of them are surcharges that, you know, they got 15 to 20 years ago and still just can't pay them off, which does seem like an unnecessary barrier for, again, the people that can't afford it, where people that can have had no issues with that. And the final thing I just wanted to, I think, I don't know if James Pepper's on this call, but I'm sure that he has also said this. I'm sure the judiciary has said this, but I wholly support the expansion of expungements. I would go beyond this even to allow state's attorneys to expunge anything that they deem appropriate, really, if certain criteria are met. But with that comes a lot of additional work on our office. In 2019, our office processed 3,517 expungement petitions. And in 2020, we did 3,497. Wow. Which is a lot of work, and it really has been put on myself and Chief Deputy State's Attorney Justin Jiren do all the review, which takes a lot of time because of, frankly, how complicated our expungement statute has become. But then once we stipulate and file them, which we are now doing a lot more of because of Odyssey, it's really difficult for people in the community to file things like this. So I'm actually doing the filing on behalf of a lot of people as well. And then when our office is processing them, Jennifer Buffard, our Chief Administrative Assistant, does all of them. And it is a lot. It's a lot of work for her, which again, we're all very grateful to do it. I just wanted to, I would be remiss if I didn't point out how much extra work it is on the offices, and how much I think automatic expungements would be incredibly helpful.
Yeah. I personally resisted automatic expungement for a number of reasons. And part of that is that I feel like a person needs to show the motivation to at least take some action to request an expungement. Maybe that's old fashioned.
Well, and also, I mean, again, kind of going back to it sometimes takes me 20 minutes just to read the statute and understand whether or not a case is eligible. And I'm an attorney. I think that to some extent, some people might read this statute and their motivation level will go down just because of the complications and not knowing whether or not their case is eligible. And then on top of that, when they call my office and say, I have this, I filled out this form, but I don't know what to do with it. I don't have an Odyssey account. Is that the only way I can file something with the court? You know, there's a lot of barriers for people that even once they do get that initial motivation to look into it, they stop because of the system that we have.
Yeah,
so
no.
I didn't have anything else specifically. Yeah, Senator Nitka.
Senator Nitka has a question, I believe.
So I'm just wondering, with regard to the Odyssey account, in order for a layperson to file that, is the fee there for them, or can the fee be waived, or is this the?
There's no fee anymore. The filing fee did get that got eliminated a couple of years ago. So they don't have to pay a filing fee unless they're sealing a DUI. I believe that still has a $90 filing fee, but
So
no, I think she's talking about the fee to Odyssey to have the case.
Yeah, the fee to Odyssey, because we're
I don't know.
We're putting
I don't know.
to Vermont Legal Aid to take care of the filing fees right now, anyway.
Well, yeah.
Get the figure out.
Once the budget adjustment bill passes, that's where the money is to continue that through March 31st.
Yeah.
So I would bring that up too, though, that there have been people who have wanted to seal a DUI and they do have a $90 filing fee, and getting that to the court while e-filing something is a whole nut. Like right now they're mailing it to me and I'm walking it down to the court so that I know that it goes in at the same time that I'm filing it for them. There's a lot of complications. And again, I'm happy to do it. It's something I care a lot about, but for a lay person, that motivation level gets less and less as each of those barriers is put up.
Thanks.
So I guess my question to different folks that are in the meeting room right now is, how can we simplify the process? So without, I suppose you could say that every misdemeanor other than domestic violence or something where there's a predicate offense could be done in a different way from some of the felonies.
Yeah, I know that there is discussion around simplifying it, and I don't have the best answer, because I know that some people think we should go to an all sealing, and I really don't agree with that, because I think that even the sealing of records gets overused by law enforcement in ways that harm people. And so I don't necessarily agree with that particular outcome. I do think that in most cases, all records should eventually be destroyed. But I do think that the multi-level and different timelines can get confusing, and
Mhm.
I don't have I think there is a committee working on that, though. I'm sure they can come up with something perfect.
We've got Judge Grierson here. And I wonder if you'd like to comment today or wait until next week.
I can briefly comment. Good morning to the committee. Good morning, Sarah.
Good morning.
Morning, Judge.
For the record, Brian Grierson, Chief Superior Judge. It's interesting to hear Sarah talk about the workload on expungements, because I can't agree more. And as the committee knows, and I believe more recently, Pat Gable has testified in appropriations. I don't know if it was House or Senate appropriations.
Had to be House.
Yeah, on the cost involved to process these. So I won't belabor that point. I've made that point to the committee before. But what Sarah's really saying, we use this word automatic, and whether it's her, even with the stipulation that she's talking about, even if the state and the party agree, there's still a work effort involved. And there is a committee, if you will, an informal committee. Myself, David Scher, Matt Valerio, Marshall Paul, Mayreed O'Reilly, and there may be some others, have been meeting informally while this bill is pending to talk about, trying to simplify the process. I think that's probably the best way to put it. Whether we'll be able to or not, I don't know. But I think Odyssey opens up some doors that were clearly not available to us before. And at some point in this discussion with this group, I will make sure that we get somebody from Odyssey involved who is intimately involved with what the program can do and not do. And so far we have not done that. But I understand Sarah's concerns about sealing. I think what this committee has been discussing, and you probably hear more from others involved, it's really a discussion of who has access, for what purpose, and for how long. Because in the final analysis, whether you call it our expungement or whether you call it sealing and eliminate any access, it's going to amount to the same thing under the Odyssey system. The court system will be an electronic system. There will be no paper files per se to be destroyed. It's a matter of an entry in a system that will say this file is confidential. There is no access. So we've got to figure out between the time of conviction, because that's the triggering event, until whatever the sentence is, it has been executed or completed, whatever term we want to use. It's that second point that is the triggering point for the time to start on. To what extent is a file sealed, or do we wait? Just by way of example, conviction today, do we wait 3 years before sealing, and then you have a period of sealing where you have to determine who has access during that sealing period before it reaches a final point that the system can trigger? The system can say 3 years after a conviction on a misdemeanor, it can be sealed. And these are the people that have access during the sealing period. And at some point in the future, let's say 2 years after sealing, all access is denied. The system can do that. The problem is picking up the intervening charges that may come in that may impact that. That's where you get into DUI that normally maybe could be expunged, but because of an intervening charge or another conviction, it won't. So we've got to work out the details of that. But the system will be different in the sense that it won't be destroying records. It will be denying access to those records. And I would like to think there's a way of simplifying this and make it more, I don't want to suggest to anyone that it's going to be completely automatic, but we can go a lot further than we have in the past. And we would like, this committee would continue to work. And I think there's a provision in this bill as it reads now, Senator, that talks about referring to the Sentencing Commission to decide if other offenses that could be expunged. And I would suggest, and I think I did in my earlier testimony, that as part of that referral to Sentencing Commission, that they explore this process of sealing and expungement so that it can be simplified. And I agree with Sarah. I can remember when a request for expungement would come in before the stipulation, or even when a petition came in, and going through the statutes to figure out whether someone is eligible at that point in time is a time-consuming process. The only other 2 points I'll make now, and I'll be glad to talk later. I do agree with Sarah on the surcharges. That was, as you indicated, Senator Sears, part of the bill last year, and I think it got lost. So we're comfortable with the language that may read as proposed. The only other issue that I wanted the committee to be aware of, and as long as Sarah's here, I think she'll be familiar with it. It's come up a couple of times in the last 6 months. I've heard from VCIC, the state and the defense are stipulating to a sealing of a case, but the individual has a sex offender registry requirement that is not addressed. And so VCIC is caught in the middle. They get an order that says seal this, but it says nothing about the impact on the sex offender registry.
Yeah.
And I don't know what the answer is, but I think it's something the committee needs to discuss.
I mean, that involves federal law as well, because there's certain consequences to not placing people on the registry who have committed certain acts. And we are, as I remind myself, we forget it, but because we don't put minors on the sex offender registry, we are docked, I believe, 10% of the burn grant every year.
Yeah, and I don't know the details of cases.
So I don't know what the impact would be.
Yeah,
it sounds.
We've had a couple that came out of Chittenden County. That's why I referenced Sarah, and I think she's familiar with them. But what they're finding is that person, for instance, might have a 10-year registry requirement, but there's been an agreement to seal the record within that 10 years. And VCIC said, what are we supposed to do? And so I just wanted the committee to be aware of that issue. And I think it's something that needs to be addressed. The more expungement that we get into, there's some of these collateral consequences that that need to be addressed.
I'm glad you brought that up. No, actually, next week, we're going to hear from the Justice Center. They've been doing some great work looking at barriers to employment and structural barriers. And Josh Grimes will be with us next week. And Peggy I hope will post by Monday. He has 3 PowerPoints. One is a playbook of national barriers to employment. One is a playbook for Vermont specific to, they looked at Vermont specifically and what we do to prevent people from getting jobs. Much of this is going to be in the government operations realm. So we're lucky to have Senator White on this committee, but it's amazing the work they've done. And they're actually some kind of a grant, and I'm not sure what it is, but would like to work with Vermont on these collateral consequences, occupational licensing, business licensing, employment, healthcare, banking, transfer, insurance, adult care, nursing homes, the whole bunch of things. So there's 3 PowerPoints that Peggy will post on our website. I believe he's going to be with us next Thursday. Is that right, Bryn or Peggy?
He is
or is
going
it
to,
Wednesday?
it is, hold on one second. Wednesday.
So if you could post that so people who are interested, can look at that before he testifies.
Do you want me to post it before Wednesday? Typically, I would
Yeah,
do
why don't we
Wednesday.
post it on Monday to not confuse people about
Okay.
what's going on this week?
Okay,
But Brendan and I met with he and the director of the Justice Center, and they're excited to work with Vermont on this. It may hold up passage of the bill, but I think it would be good to be able to include some of these hindrances, and it goes beyond expungement, but many of our areas are unrelated to whatever job the person's looking for.
Senator, I can just add to the comments Sarah made about the self-represented litigant who
Yep.
doesn't have access to Odyssey. I checked while we were talking, and much like a person comes to the court now with their petition for expungement, or used to, they can bring their hard copy, their paper to the court, and the court staff will scan that into the system, so it will become without charge. So essentially, for the self-represented litigant without access to Odyssey, it's the same process. They come to court with their paperwork and it's scanned in by the staff.
I don't know. I don't know that they can do that right now, but they could mail it, I assume, right?
Well, as long as they get the paperwork to court,
Yeah.
it'll be
Okay.
scanned in, and the
Great.
process would be the same.
I agree with everything that we can do to simplify the process for the person. It can be intimidating trying to understand, and I've worked with a fellow who's getting a records expunged, and he was thrilled to get 3 of his 4 crimes expunged, but then he finds out that one of them can't be expunged under the current law. And this bill would change that to allow him to expunge everything. He had no problem getting rid of 3 of them, but then the 4th one is a hindrance, and that continues a barrier for him to be able to do certain things. So I think that we should do whatever we can to simplify it. Both the judiciary, the state. I'm interested in one thing you said, Sarah, that I'd like to expand on further, is the effect of sealing versus expungement, and how you we've been talking about both sort of as idea, if it's simpler to seal, then let's just do sealing. Can you comment further on that? Why you're opposed to sealing?
I'm not opposed to it. I think that I would echo what Judge Gerson was saying, that I think it more so depends on who has access to that while it's sealed. Because right now, my understanding at least is that all law enforcement have access to that. Even the individual who's out doing traffic stops and can access somebody's sealed record from 15 years ago and use that as a pretextual stop. Whether that ultimately holds up is another question, but I think that even within law enforcement, it really needs to be limited by who can see it and for how long. I think that really the only reasons we should be able to see particular prior conduct is if it's a subsequent offense and recent. Otherwise, I think that they are going to continue. It won't hold people back necessarily in the community and housing or other issues, but it will continue to hold them back within the legal system in ways that I think only perpetuate all of the same problems that we already have. And certain prosecutors will use old offenses against people that they, in my opinion, shouldn't be able to. So I just think the people that do a lot of the harm from using prior convictions against people are still going to have access to it and can still continue to harm them. And I think that especially when it comes to, it actually does ultimately hurt them in housing, because if we're using those to ask for example, a case we maybe would have done some other alternative process for, but we see that they have this prior case that's similar from 15 years ago, and so we require that they go through the regular system and get another conviction. it just perpetuates the cycle for those individuals. It really doesn't allow them to fully move on when the people that can use it against them have access to it. But if it's recent and it's a subsequent offense, then I understand the importance of that. And I think those cases, we should be able to see that somebody got a DUI 2 years ago and, you know, is getting another one. That makes sense to me. But somebody having a felony from 20 years ago, a felony property offense, for example, that has long since done what they needed to do on that case and just ran into some other issue 15 years later, I don't think we should be able to use that against them. And it will get used against them by some prosecutors.
Yeah. Do you have that same experience with the juvenile records too? Which have been sealed. I mean, I don't think we ever expunge juvenile records, do we?
I don't know. We certainly don't in Chittenden County. We don't look at those when somebody is out of the system. I mean, we've certainly had conversations. If a particular prosecutor knew that they had a case with that child, they may mention it, but we don't use that information in the criminal cases. But we could. You know, I'm speaking on behalf of Chittenden County. We could use it against them, and law enforcement could use it against them if they can have access to it.
They can.
If they have access to it. I mean, whether they're actually using it against them, like they have that in their head, their biases could be triggered. They can use that information, whether they say they're using that information or not. I have had law enforcement say, I saw that this kid had this particular violent offense when he was 15, like this isn't his first time. Those types of conversations happen when we're trying to get a 19-year-old, especially now, into youthful offender. We've had law enforcement bring those up, like, well, this isn't his first time. He shouldn't get a youthful offender status because he did this sort of thing when he was 15. So that's what I mean by they do use it against them in wanting a particular outcome.
That's helpful. I thought this was a simple bill because we passed it last year and there wouldn't be any problem. I guess maybe I'm making it more complex, but there are problems with the current system, and hopefully we take another look at the bill and do whatever we can to make it as simple as possible for somebody to get their records expunged and remove the barriers. If they're eligible for expungement, if the state agrees, the judge agrees, there's no reason why we should make it difficult. Anybody else would like to comment on this right now?
You know, Senator, the only other thing I would add, the only other thing I would add is under the current statutes, as to both sealing and expungement, the phrase is that if the court is asked, the phrase is there is no record, and that applies to whether it's a sealed or an expunged record. And so in that sense, they're similar. And again, I'll just repeat myself that with the case management system, it should be easier to manage that electronic file and hopefully eliminate some of the steps that are now part of this process. But I would agree with Ms. George that it's a question of access. Who and how long and what do they have to do to get that access? If we can resolve that part, then I think whatever we call it, sealing or expungement, is not critical. It's the access and for how long. Thank you.
Thank you. James Pepper.
Thank you.
Thank you, Sarah. Appreciate your being with us. James Pepper, did you have a comment?
I had, yes, for the record, James Pepper from the Department of State's Attorneys and Sheriffs. And I just want to thank Sarah George for all of her work on expungement. Her office I think she mentioned 3,500 expungements just last year, which is an incredible undertaking. With the help of legal aid, of course, who's been just so incredible getting all of our state's attorneys on board and comfortable with expungements and sealings, and has held, I think, expungement clinics in every county of the state, helping people navigate this very complex process. I have one substantive comment on the bill, if that's appropriate for this time.
Yeah, absolutely. We've got about 25 minutes to continue talking about this.
Okay. So, and I've raised this with at least some of the stakeholders that are in this, kind of informal subcommittee on sealing. And what this bill does is it expands eligibility to a number of crimes. In fact, all the crimes except for the non-listed crimes, and it applies to all non-listed and non-drug trafficking crimes. So it also allows the respondent, which could be either the state's attorney or the attorney general, to stipulate to waive a time period, the waiting period for any crime. And that is a good thing, and it's something that the state's attorneys have asked for in the past, the ability to waive certain time periods. Where we get a little bit nervous is that there's this concurrent jurisdiction between the state's attorneys and the attorney general for waiving those time periods. And so the office that prosecuted the case is not necessarily the office that would be allowed to waive that time period. And that gives us a little bit of pause, especially considering the victim notification that's required under 7608. So, it's the office that prosecuted the case that I think should be in charge of determining whether to waive the time period or not, and do that victim notification. It's the office that prosecuted the case that has the victim advocate, that has the relationship with the victim, that should be the one reaching out to that victim and seeing if there's any objection to the sealing or an expungement. And I would say that I think without exception, when people are eligible for expungement and they don't have any disqualifying criteria, and the victim has had an opportunity to weigh in, it's very, very rare. And I think it would be difficult to find many cases where a state's attorney has not granted an expungement or a sealing. But I do think that it should be the office that prosecuted the case that is in charge of determining whether or not to waive that time period.
Bryn, do you have that as a possible amendment?
I have not talked to Bryn about that, but I'd be happy to.
No, I do now, but
Yeah, okay, I'm sorry. I thought, I understand. What about when they do the clinics, though? I mean, you have the state's attorney and the attorney general there.
If that's the case, then if there's that open line of communication, that's fine with me. It's just that we've seen a couple of times where an expungement petition has come through where the state's attorney had not been notified, and it was because it was done. And I don't know the specifics of maybe, there was an attempt to notify that just didn't happen, but we've seen one or two instances around the state where, a sealing order or an expungement order comes through and the state's attorney had no idea. So.
Can, David, did you want to comment on that, since you're the attorney, you're not the one, excuse me, you're the attorney, you're representing the Attorney General's office.
Sure. Thank you, Senator. And for the record, David Scher with the Attorney General's office. On that point, it is the case that we have concurrent jurisdiction, the way the statute's written, to stipulate to expungements if we chose to. It's my belief, it's my understanding that in every case in which we've done that, there has been consultation with the state's attorney's office involved. I understand there's different evidence being put in front of the committee, but that is not my understanding of what's happened. it is the case that I have, excuse me, I have standing permission actually from the Chittenden County State's Attorney to review and stipulate to expungement petitions out of Chittenden County. And when David Cahill was State's Attorney in Windsor County, I had similar standing permission to do that. This was especially relevant during the clinics that you're talking about, where even though they take place in one county, people don't often realize that they're, or whether they realize it or not, we get petitions for cases that were coming out of all counties at these clinics, even if they're aimed at one specific county. So it was often very useful for me to be able to do that. And in cases where we didn't have standing permission, there have been times certainly when the Attorney General has felt that a expungement or stipulation was warranted. But my belief was that, and what I witnessed being present at the clinics, is that the Attorney General would call the State's Attorney and say, look, I really think this is one that's worthy of stipulation, and I'd like to sign it and talk to them about it. So I don't know, I don't know the specifics of the cases that Attorney Pepper's talking about. I do think it's useful in volume management, especially for some of these big counties, to be able to have these cooperative agreements. I would certainly never stipulate to a petition unless I had some sort of permission from the State's Attorney, and my belief is that is the policy of our office. And really nobody else in our office, frankly, deals with expungements other than me. But yeah, so our position would be that it is useful and helps deal with volume management and can be a useful tool to have the Attorney General's office able to review these as well. I understand that's perhaps a point of disagreement with us and some of the state's attorneys, but just wanted to put that out there.
Right. Thank you. Pepper?
I would actually agree with most of what Attorney Scher has just said, and that I do think it's useful for there to be this concurrent jurisdiction with respect to sealing and expungement. What I'm just talking about this additional provision that would allow the respondent, which is either the state's attorney or the Attorney General under current law, to waive the time period. I think that could mean a person is convicted of a crime today, and then tomorrow the Attorney General could come and seal the petition or stipulate to seal the petition when that office was not involved in the prosecution. So I'm only concerned about this additional new authority that's being granted that would allow either the state's attorney or the Attorney General to waive that kind of waiting period, which is permitted under S7.
All right, we should highlight that when we get to markup. There was a discussion about careless and negligent driving. Where are we with that, Matt? Valerio, I think somebody brought it up. Is that expungable?
Are we talking about negligent operation with serious bodily injury or death resulting? No. That's what I think we were talking about. I believe those are listed currently. And if listed crimes were being excluded, then they wouldn't be expungable. But to me, those are usually negligent acts that over a period of time, if there are no further problems, should be subject to treatment like other negligent acts and allow expungement. There's not a criminal intent necessarily in what there's not a criminal intent necessarily, but by definition, it is a negligent act that we have chosen to criminalize. So, to me, at some point, they needs to be something that comes off the record if there aren't any other problems. I mean, there's what I think about when I think about, worthiness for expungement or for or sealing is what type of are you intending to commit a crime? Are you intending to do something that is criminal? Is there some sort of criminal thinking or, I don't want to use the Latin, but the bottom line is a criminal element to your thinking that gives rise to what the state has deemed to be a crime. And to me, the negligent or unintentional type acts are the types of things that are not the product of criminal thinking. They are the product of mistake. They are the product of inadvertence or negligence or not paying attention. Where if you can get that under control and understand that you need to pay attention, that you need to be attending to detail and the like when you're driving. Those are the kinds of things that down the road would warrant an expungement and sealing. And I use those two words interchangeably. I know, and it just confuses things, but I can see we're going to ultimately distill this down to what is the equivalent of expungement, no matter what you call it. So, to me, I'm trying to get at the concept of what sorts of things are worthy of expungement on their face because of the lack of criminal thinking that went into the crime to begin with.
Thanks. That's actually helpful. Sometimes
Senator,
I wonder
if I
how
might-
things get on certain lists. When we've created lists of the big 12 listed crimes, we add to those lists, we do things with them that sometimes. Is it the correct? I don't think.
Well, I mean, it's clear over the years that the various victims groups and advocacy groups have had, access the legislature to help expand the list of listed crimes from the old common law Mrs. Baker crimes, or what you call the Big 12 now. But that was a time during the early 90s and the like when criminalization of a lot of behavior started to erupt, particularly regarding alcohol, drugs, and domestic violence. And we keep talking about the domestic violence as being one of the things that we keep excluding from things. I'm just mindful of a seminar that I actually went to attended last Friday with a professor from the University of Maryland who was an advocate during the 90s regarding the domestic violence issues, and she says, one of the people who got domestic violence on the various lists as like listed crimes and the like. And then she studied the issue over the last 30 years and has now come to the realization that we've done it completely wrong. And that we need to deal with domestic violence in a different way. I really wish that the legislature at some point would give her some time to, whether it's in this committee or another one, or depending on the time frame. Her name is Lee. I'm sorry, Lee Goodmark, and she's a doctorate professor at University of Maryland Law School. And she talks about the ways certain European countries have addressed domestic violence in a way that has made progress on recidivism, where in the United States, despite our efforts, we really haven't made the type of progress that you would hope on the subject. In any event, separate issue, but it's clear how these lists expanded over time as interested victims groups became more active in the political process.
I was just looking for through my file of the last one, looking how the bill last year, and interesting. My note from Sarah George, need to simplify the system. This is 12720. Senator White.
I was just going to comment on what Matt just talked about, because I have, and I know this has nothing to do with the expungement thing, but it is a follow-up on that. I know that we will not allow domestic violence cases to go to the criminal justice center or community justice centers. They're excluded from that. And I know that when the sheriff down here was doing his ankle bracelet program, they said you cannot do DV cases. They aren't eligible. They shouldn't ever happen. And he convinced the state's attorney and everybody to allow this person to do it. And it was the best thing that had happened both to that person and to the victim. So I think that we lump these things in, and it doesn't make any sense. And I agree with Matt. We really should be taking a deeper look at that.
Thank you.
It's one of those things that we probably just need to look at, just by virtue of the fact that we aren't really making a lot of progress on it with what we're doing. So unless there's no way to handle it ever, and we just throw up our hands and say it's something that has no remedy, then look at other things. And as I understand it from Dr. Goodmark, that there are programs that have worked in Europe and in other places that show good promise with recidivism and the like on the domestic violence front. But it's not the way we address things here.
Senator, if I might comment on the careless operation, careless and negligent operation.
Please do,
So the comments just now spurred me to do a quick search through both the bill and current law. By way of background, it is currently one of the perverse outcomes of our statutes that somebody can get a DUI sealed, but cannot get a careless and negligent operation sealed, even though DUIs often get pled down to careless and negligent. So it's a bizarre outcome. But the reason why they can't get them sealed is because they're predicate offenses, and predicate offenses are not eligible for expungement or sealing. It was the intention of this bill to include a bunch of predicate offenses and allow predicate misdemeanors to be sealed and or expunged. But looking through the draft, I just noticed what I think might be an error. But if somebody has knowledge that this was a purposeful change, let me know. We can discuss it. But on page 3 of S7, lines 15 and 16, it looks like there's an amendment to the listed offenses proposed that would in fact expand what is currently limited. The listed offense is currently limited to grossly negligent operation resulting in serious bodily injury or death, as defined in subsection B of the relevant statute. And it looks like there's an amendment that would open it up so that the listed offense would become any negligent or grossly negligent operation. So I just wanted to flag that, because my sense is that it wasn't the intention to open that up, but maybe there's some debate I'm misremembering. But if in fact that change were to be made, then we would be left with a system where that couldn't be sealed or expunged. And I don't think that that was the intention, but again, I defer to.
I'm confused, so I need some help, Bryn. Are we saying simple gross negligent operation can't be expunged?
No, so that was not the intent. The Sentencing Commission report that was issued last year recommended an update to the listed crime statute that would correct the cross-reference. And I had quite a few discussions with various individuals last year when I was working on the bill. So that removal of subsection B, and I recently talked to Marshall from the Defender General's office about this. And in the next draft, that subsection B that's removed in the as introduced version was going to be replaced.
Okay.
So the intent here was just to correct the cross-reference and not to expand what's considered a listed crime.
Good.
Thank you.
Thank you.
Senator Sears?
Yes, Chris.
Chris Fenno, for the record, Vermont Center for Crime Victim Services. I just wanted to state, because of the conversation, not just what happened, but the conversation about domestic violence and excluding it from things. And, you know, I've worked in the domestic violence field for over 30 years, and we have learned a lot. And I just want to assure, and I see now that Sarah Robinson is on this call, but I want to assure folks that the network programs, and then nationally, people are working on these issues. They're hard issues, just like trying to reform the criminal justice system, how to keep victims safe and what that looks like, and how we can make sure and ensure that our communities are safe for everyone is number one thing. And there are literally thousands of people working on this issue.
Thank you. Yeah, in Brattleboro, it was the domestic violence network program. And I believe the Bennington network program also supported the use of ankle bracelets for domestic abusers who were getting treatment or whatever you want to programming. I shouldn't say necessarily programming. It allowed them to continue their jobs, pay child support, other things.
And
I know that PAVE was actively involved in Bennington. I don't know what your women's network program is called.
The Women's Freedom Center, but it also allowed the victim to know at any point where, if the violator had strayed off and gone someplace where he or she wasn't supposed to go. It was a good program.
I would agree. Sorry we lost it.
Yeah, me too.
It being almost 10 o'clock. Sarah, did you want to make a quick comment? Then we'll come back to this next week.
Sure. I would just say, we're very supportive of these ongoing conversations. And Senator White, I know we've been in conversation with the Attorney General's office about the current carve out that there is around not referring domestic and sexual violence cases to community justice centers. So I just wanted to assure the committee that those conversations are very robust and ongoing. And we certainly hope to come back, in the coming years with some policy proposals. But conversations are ongoing, lots of stakeholders involved in those. And we very much see the potentials for diversion and restorative justice to have more of a role in domestic and sexual violence cases than they do right now.
Good, thank you.
With that, we'll take a break until 1/4 and then pick up with one of the yes. All right. Lost my agenda. S18. Thank you. Lost my agenda. There it is. Pick up with S18, which is a bill regarding earned time. We're going to sign off YouTube for 15 minutes and be back at 10:15. Thank you.